Good afternoon, everyone. This is Joseph Thomas from Trust HR, and I'd like to welcome you all to our webinar as we learn about the Form I-9 process and answer any questions you may have on I-9 compliance. Before we get started, I do have a few housekeeping rules to go over. First off, this webinar is being recorded, so everyone who has registered for the webinar will receive a copy of the webinar recording. Next, a copy of the presentation slides as well as any other supporting documents for the webinar can be found in our Handouts tab. And finally, all attendees for this webinar will be in listen-only mode. But if there are any questions, please feel free to write them down in the questions tab, and our panelists will make sure to answer them. I'd also like to take the time to thank our partners for helping to sponsor this webinar. So to the teams at Corporate Cost Control, PDS, ESR, Performance Screening, and Castle Branch, I want to say thank you for your support. And for those of you who may be unfamiliar with our services, allow me to share a brief overview of what we do. Here at Trust, we provide an HRIS platform to support your talent acquisition, management, and employee onboarding needs, with modular services in employee onboarding, Form I-9, and E-Verify built into our system, as well as powerful and great integrations through our partner network to provide you with support for WhatC and connect with your ATS, payroll, ERP, and other HRIS systems. We also offer straight integrations to companies such as PDS Vista, UltiPro, ADP, Workday, SAP SuccessFactors, or Oracle, just to name a few. And our clients range from small organizations to large enterprise companies in many verticals. We have well over 500 clients with various onboarding needs. And for those clients on the call with us today, I'd just like to express our gratitude and thank you for your continuous support. Okay, now in moving on to today's agenda, we'll first follow off with speaker introductions, then relay some information about the I-9 process and recent updates. And then we'll move on to answering questions that have been submitted by you, our audience, for this webinar. Once again, if there are any additional questions, please feel free to add them down in the questions tab. All right, without further ado, I'll pass it on to Dan Price, the Regional Sales Manager at PDS, to introduce our main speaker. And Dan has been a great friend to the Trust team, and PDS has always been a reliable partner. So we're very lucky to have him join as one of our key moderators for this event. All right, Dan, please take it away.
Thank you, Joseph. I'm Dan Price. I'm the Regional Sales Manager for PDS. PDS is a HCM technology solution provider that partners with Trust to do some advanced onboarding services for hundreds of our customers. Today, I have the honor to introduce our expert today and speaker, Gloria Aiken. Gloria is a graduate of the George Washington University out of DC. She has a journalism degree. She joined the U.S. Citizenship and Immigration Services as a management and program analyst in 2004. But prior to this, Ms. Aiken worked in the legal field as a paralegal and wrote healthcare policy for Blue Cross and Blue Shield Association. Ms. Aiken is published author and ran for political office in Prince George's County. And Ms. Aiken is routinely delivering presentations for congressional events, and she has provided testimony on E-Verify before the Utah State Legislation. Also, several counties have used her services and expertise as a speaker to develop Form I-9 and other best practices. Ms. Aiken has been a public speaker for over 10 years and is a former owner herself of an income tax preparation business. So without further ado, I'd like to introduce Gloria and wish her and thank her for spending her time with us today.
Well, thank you, Dan, and good afternoon, ladies and gentlemen. It's so nice of you to take time from your day to join us and to allow me to speak with you about Form I-9 policy as well as some recent Department of Homeland Security updates. Next slide. Next slide, please. And also, ladies and gentlemen, let me let you know that the slides are being moved in a different location. You know, we all are kind of hunkered down right now due to the COVID-19 virus, and, you know, we all are working from separate locations or what have you. So, again, you'll hear me say next slide, so hopefully it won't be too annoying for you. Okay, what you see in front of you, of course, is the agenda, and I'll be discussing the background of the Form I-9 and how to complete each section of the Form I-9, and that would be, of course, Section 1, 2, and 3. And for those sections and areas of the Form I-9 that I think most of you are very familiar with, I won't really get into a lot of detail in those specific areas. And we may get into a little storage and retention if we have time, as well as some additional resources towards the end. Okay, next slide, please. Okay, as you all well know, back in 1986, Congress did pass the Immigration Reform and Control Act, and this is the law that ushered in the Form I-9 instrument that we now use. Okay, next slide, please. And what you see in front of you, of course, are the individuals who may work legally in the U.S., and they are citizens, of course, of the United States, non-citizen nationals, lawful permanent residents, as well as aliens authorized to work here in the United States. Next slide, please. And again, as of 1986, all employers are to verify the identity and employment authorization documents of all employees that they hire. And again, with that law, we do ask that all employers not engage in any form of discrimination based on national origin, citizenship, or immigration status. Next slide. Okay, and again, these are some unlawful conducts that we ask employers not to engage in, and specifically, again, that national origin discrimination, because sometimes if an employee may look foreign or something, foreign born to an employer, they may ask, where were you born? Were you born here in the United States? Or do you have a green card? That would be a form of document abuse if you ask about a document that an employee presents to you. So we do ask that employers not engage in those forms of discrimination based on national origin or any form of document abuse. And we do ask that employers do not engage in any form of retaliation against an employee if they were to participate in any type of legal proceeding held by the Department of Labor, the Department of Justice, or the Department of Homeland Security. Next slide, please. Okay, and what you see in front of you is a slide pertaining to the Immigrant and Employee Rights section, which is an arm of the Department of Justice, and we do ask employees to contact my office or IER if they feel that they have been subjected to any form of discrimination, or if they feel that their information has been misused or abused during that Form I-9 or a Verify process. And employers can contact IER as well if they have any types of questions regarding accepting a document, rejecting a document, or if they feel something is just amiss maybe with an employee or any information that the employee may have presented. So employers, you may contact IER at 1-800-255-8155. You can speak with them anonymously. And when you do have, or if you have any type of employment-related questions, I would suggest that you contact your general counsel's office, or please do feel free to speak with IER. And again, you can speak with them anonymously. Next slide. Okay, so please do ensure that you have the most current version of the Form I-9, which now is that date of the most current version is October 21st, 2019. So ensure you're using this version of the Form I-9 because we do consider all other versions of the Form I-9 to be obsolete and they should not be used. And later on in the presentation, you'll see some information pertaining to I-9 Central where you can go and download a copy of the most recent version of the Form I-9 if you do not have it. And do keep in mind, looking at the third bullet point here, that you may delegate the authority to anyone to complete Section 2 of the Form I-9 on your behalf. It can be a notary public, or it can be a manager in the field, or whomever. But please do keep in mind that you, the employer, will retain all liability for any errors contained in those Forms I-9. Next slide. Okay, what you see in front of you, of course, is the Form I-9, which is 2 pages long, but the instructions, as you well know, are over 10 pages. I think they're about 15 pages, but we're working on that to kind of condense some of the information so it won't be too burdensome for employers. Okay, and regarding the Form I-9, there are some exceptions. You do not have to have a Form I-9 on file for individuals who are working in a household in a domestic service capacity, and particularly if they are working on a sporadic or intermittent basis. You do not have to have a Form I-9 on file for them, and these types of individuals, tend to be like a babysitter. And looking at bullet point number 2, and of course you do not have to have a Form I-9 on file for contractors because they are not your employees. Sometimes we do get that question, but no, you don't have to worry about that because, again, if the contractor is not your employee in any sense, you do not have to have a Form I-9 on file for them. Also, if you have employees who are working outside of the United States, you do not have to have a Form I-9 for them. However, if they complete any type of work, orientation, or training on U.S. soil, you must have a Form I-9 completed by that employee. And of course, our definition of the United States includes all 50 states, the District of Columbia, Guam, Puerto Rico, the U.S. Virgin Islands, and the Commonwealth of the Northern Mariana Islands. Next slide. Okay, what you see in front of you is the list of acceptable documents. Many times I get questions from employers regarding accepting a certain document. They're not sure if they should or they shouldn't. Easy answer. If that document is not on this list of acceptable documents, please do reject it. Give the employee this list and have them select a document from this list only. And there's about, 20, 25 different documents for an employee to choose from. So it's enough here where they should be able to present a document from this list. And also, please do keep in mind that a List A document establishes their identity as well as an employee's authorization to work here in the United States. If they present a List B document, they must also select a document from List C as well. Next slide. And what you see in front of you, of course, is Section 1, and this should only be completed by the employee. The employee can have a representative help them to complete Section 1. That could be a relative or even a manager could assist the employee in completing Section 1. But again, if there's an error, if you find an error or what have you, immediately call the employee into your HR office and have them make the correction to Section 1. So the employer should not make that change or corrections to Section 1. It should only be the employee. And keep in mind as well, this is a legal document, so it is important that employers comply with the various rules that are in place for completing the Form I-9. And here, this is the attestation area, of course, and looking at the red box or the box outlined in red, this is where an employee is to attest to being a U.S. citizen, a non-citizen national, a lawful permanent resident, or an alien authorized to work here in the United States. Some employees don't take this area as seriously as they should. They can be removed from the United States if they attest to being a U.S. citizen and they are not. So that's why it's very, very important that employees attest to their lawful immigration status or citizenship status. And of course, they will sign and date the document. Oh, and before we move on, very important, looking at the second bullet here, all employees must complete Section 1 no later than that first business day when they begin to collect pay for work. And ICE would prefer that the Form I-9 is completed first thing in the morning. So please don't wait until after lunch or after training or orientation to have an employee complete Section 1. That should be the first thing that they do. If they come into work at 8:30 a.m., at 8:30 a.m., they should be filling out Section 1. Okay, next slide. And this is the area where whomever assists the employee in completing Section 1 would fill in their information. This is called the Preparer and Translator Certification area. Next slide. And this is Section 2, of course, and this is where the employer or the employer's representative would fill in information from the documents that the employee presents to establish their identity as well as their authorization to work in the United States. And looking at bullet point number 2, Section 2 must be completed no later than 3 business days after the employee begins to collect pay for work. And also keep in mind that if the employee does not have the requisite documents on day 1 to establish their identity and their authorization to work in the United States, you can give them up until 3 business days to present those documents. Because, of course, on day 1, a person may leave the house and forget certain things, so we understand that. However, if they do not bring in those documents by that 3rd business day, that employment should be terminated because, so far as we're concerned, they were not able to establish their identity or their authorization to work here in the United States. And only employers should complete Section 2, and it should be completed in the presence of the employee. Sometimes employers will make the mistake of allowing the employee to complete Section 2 because they feel like, well, the employee has the information right there in front of them, the employee has the documents, and they'll just go ahead and let the employee complete Section 2. But please do not make that mistake. And looking at the 4th bullet point, all documents must be original and unexpired. The only exception would be a certified copy of a birth certificate. Okay, next slide. Okay, regarding the various changes in working here due to COVID-19, DHS has put in place some flexibility, and that flexibility can be found, or the flexibility information can be found on a memo that DHS issued on March 20th. And we do ask that employers monitor the DHS and ICE websites for additional updates. Next slide. Okay, regarding the information on that March 20th memo, for those of you who may not be totally familiar with it, again, because most employers and employees, we all are working remotely, so employers must inspect the Section 2 documents remotely and obtain and inspect, let's see, there's a little, let me see if I can move this box that's blocking some of. Okay, hold on. Okay, here we go. Sorry about that. Had a little technical difficulty, but looking at paragraph number 2, employers must inspect the Section 2 documents if they are working remotely and obtain and inspect and retain copies of those documents within 3 business days for Section 2 purposes. And please do ensure you write the word COVID-19 in Section 2 in the additional information box. And within 3 days of normal operations, the employer should physically inspect those documents that the employee faxed over or emailed, or there was some type of video link associated with receiving those documents. And also, the employer should write the words documents physically examined in that additional information box with the date of inspection, as well as you would do that for Section 3 as well. If you do have a rehire that comes back to your company during this temporary period, in Section 3, you would also write that same information. Okay, and looking at the last paragraph here, these provisions may be implemented by employers for a period of 60 days from March 20th or within 3 days after the termination of the national emergency that was put in place by DHS. And again, for any additional information, please do see that March 20th memo that DHS issued, and you can find it on the ICE website or the Department of Homeland Security's website. And regarding E-Verify, for those of you who are E-Verify participants, E-Verify is extending the time frame as well to take action to resolve Social Security tentative non-confirmations. And as you well know, if you are an E-Verify participant, a TNC can be generated when you key information into E-Verify, and if it does not match the government's records, a TNC will be generated by SSA or DHS. However, right now, that time frame has been extended. Typically, an employee will have 8 federal government work days to begin that case resolution process, but for now, the 8 days has been relaxed. And so again, employers, please do not take any type of action against an employee just because a tentative non-confirmation has been generated. So looking at the first bullet point, we ask employers to notify the employee, although they are working remotely, notify them about the TNC as soon as possible. And after the employee is notified of the TNC, and if that employee does decide to take action to resolve that TNC, the employee should acknowledge that decision on the further action notice. So the various documents that are in place, they remain in place, although we all are kind of working remotely. And looking at the third bullet point, employees who choose to take action to resolve that TNC should still be referred to SSA and or DHS. And very importantly, the last bullet point here, employers may not take any adverse action against an employee because that E-Verify case is in an interim status. And this is, again, because of the fact that the time frame has been extended. Okay, next slide, please. And regarding examining documents in any setting during this COVID-19 situation going on, or in real time, or when normal operations resume, employers, we don't expect for you to be document experts, so don't feel that you have to closely examine the document that an employee presents to you. However, please do ensure that that document represents the person that is presenting it. So for example, I'm African American, and if I were to present a document that had blonde hair and blue eyes, well, of course, that does not represent me. You would be free to reject that document. Our general counsel has stated many times that it's a judgment call on the part of the employer to the extent that we all change our appearance. You may change your hair color. You may change your hairstyle, gain weight, lose weight. Of course, that's going to happen. But again, the employer has the leeway to go ahead and make that judgment decision because you have that employee in front of you. So if that document reasonably represents the person that is presenting it to you, please do accept it. However, you're well within your right to reject that document if you think that that document does not represent that person. And again, all documents that are presented to employers must be original with the exception of a certified copy of a birth certificate. No photocopies are acceptable. Okay, next slide. Okay, what you see in front of you is a picture of, or a couple of pictures here of green cards that have been redesigned. So just want to give you a permanent resident card as well as an EAD card, employment authorization document. So just want to kind of let you know that these documents look a little different these days than they may have looked 5, 10, 20 years ago. So please do accept these documents, you know, when an employee presents them to you, although, as I say, they may look different to you than what they had looked previously 5, 10 years ago, what have you. Okay, next slide. Okay, regarding automatic extensions for employment authorization documents, as of January 17th, 2017, for certain visa categories, that would be the EB1, EB2, and EB3, their status has been automatically extended for up to 180 days. And so that employee can present this is an exception, that employee can present a expired EAD card, but that employee must also present a Form I-797C along with that EAD card. And for more information regarding automatic extensions, please do go to the Handbook for Employers. It is your Bible to the Form I-9. Any question that you may have regarding the Form I-9, you'll be able to find your answer in that Handbook for Employers. And that is also located on I-9 Central. And a little later on, you'll see the slide for I-9 Central, where you can go and get that most current version of the Form I-9, as well as the Handbook for Employers. I strongly encourage you to get the Handbook for Employers if you don't already have it. Next slide. Okay, regarding the receipt rule that is in place, I won't go through everything here, but an employee looking at number 2, they can present a Form I-94, I-94A that has a temporary I-551 stamp, as well as looking at number 3, the departure portion of that Form I-94, I-94A, if it contains a refugee admission stamp on it. Okay, next slide. Okay, regarding copying those evidentiary documents, certainly your prerogative to decide if you'd like to make copies of the driver's licenses or employment authorization documents, or you may choose not to. However, if you do make the choice of copying documents, you have to do it across the board for all of the documents for all employees. So, for example, we ask employers, like, please don't just copy permanent resident cards, but you don't copy driver's licenses. If you choose to make copies of the permanent resident cards, again, you have to make copies of all the documents for all other and all the documents that an employee presents to you, and that would pertain to all employees. Otherwise, it could be perceived as a form of discrimination, natural origin discrimination, or immigration or citizenship status discrimination. And of course, these are forms of discrimination that we ask employers to not engage in. Okay, next slide. And I'm going to take a quick sip of water, so just a minute.
This is Dan Price. Feel free to put any questions in the chat area if you desire to plug in any information and ask questions. We'll be monitoring it.
Okay. Yeah, thank you, Dan. an audience may not have been aware of that. So yeah, that was a nice reminder. And so what you see in front of you, of course, is Section 3, and this is where you're going to record information on your rehires, as well as any document that's presented to you that has an expiration date. And you're going to want to update that employment authorization before that document expires, okay? And it's incumbent upon an employee to ensure that they have current employment authorization documents to present to you before the expiration of that document that you may have on file. Also, it's good to update Section 3 whenever you know of a name change for an employee. Maybe an employee got married and you update their pension plan information, their health care information. So please do update their new name in Section 3 of the Form I-9 as well, because you do want your Forms I-9 to have the most current information on your employees. Okay, next slide, please. So sometimes employers will ask, well, when do you do your re-verifications? When should I do that? Looking at the first bullet point here, when the employment authorization document has an expiration date, or you want to update a Form I-94 that has that temporary I-551 stamp, an unexpired foreign passport that has a temporary I-551 stamp. And please do keep in mind that you never have to re-verify a U.S. passport or passport card, the permanent resident card, or any List B documents. And of course, that includes driver's licenses. Next slide. So when you need to make a correction on the Form I-9, or when a correction needs to be made, such as in Section 1, you want to immediately call that employee in and have them make that change to Section 1, and it's very easy. All you have to do is just cross the line through the incorrect information and just initial and date that correction. And at any time that there's a discrepancy or there's some type of problem, or you don't know what happened with a certain Form I-9, it's always easy to just go ahead and have an employee complete a brand new Form I-9. So, and you can just attach the old Form I-9 to the new one. And again, looking down here at the last three bullet points, please do ensure that this is done immediately. And the last bullet point here, do not backdate the Form I-9. What we mean by that is if an employee starts work, let's say May 10th, 2019, and you discover maybe your predecessor did not complete Section 2 of the Form I-9, and now this is May 7th, 2020, you would have to sign and date it May 7th, 2020. You could not backdate it to the date of the employee's hire. So that's what we mean by do not backdate. And you would just attach a short memo to that Form I-9 explaining the difference in the dates, because of course the Form I-9 should be completed no later than 3 business days after the employee begins to collect pay for work. But here it is a year later and you're just now doing it. So if there was any type of audit, you would forget, well, gosh, I don't remember why there's a difference in the dates. So that's why it's important just to do a little short memo. Okay, next slide, please. Okay, let's talk a little bit about storage and retention here. And again, please ensure you have you have a Form I-9 on file for all of your current employees. You can store your Forms I-9 however you like. You can store them electronically, or if you want to put them in a warehouse or what have you. But please do keep in mind that if you were to get a notice of inspection from ICE, the Department of Labor, or the Department of Justice, you would have to have your Forms I-9 available within 3 days to turn them over to the government. And of course, you want to look through your Forms I-9 and be sure everything is complete before you turn them over to the government. So it's important, I would suggest, to have your Forms I-9 accessible to you so that, again, you could go ahead and go through them before you turn them over to the government. And looking at the last bullet point, ensure that all the Forms I-9 have a signature and date. Next slide. Well, regarding retention, there is a rule, meaning retention of the Forms I-9. We don't expect for employers to stockpile Forms I-9 5, 10, 20 years after an employee has left your company. However, there is a retention rule for your legal obligation for retaining that Form I-9. So that rule is 3 years after that hire date or 1 year after the employment terminates, meaning you look at that hire date, and in this example, it's November 1, 2017, and the separation date is July 5th, 2018. So you would add 3 years to that hire date, which becomes November 1, 2020, and you'd add 1 year to the separation date, which is 2019. You compare the dates, and whichever date is greater, that is when your legal obligation ends. So in this example, an employer's legal obligation for retaining that Form I-9 would end 11/1/2020. So after that date, an employer is free to throw the Form I-9 away, burn it, or whatever you'd like to do, but your legal obligation for retaining it has ended at that time. Okay, next slide. Okay, we're not going to really get too much into E-Verify, I don't think, Thomas. Is that correct?
That is correct, yes. So we're going to go back into, we're going to take a few minutes maybe to go back into questions that team members or people, audience has asked us. We had a lot of questions, I think, from people who actually registered. So we wanted to get to that questions, Gloria, and I think we have actually prepared those out for you. But before we do that, for the audience, we have a quick little poll that is going to come up for you. And that will allow Dan and the team to take a look at the questions and start to filter out questions that maybe we need to send out to you, right? So while we are doing that, from the audience, we do have a polling section here. And I'm going to select a poll. So if you can take a minute to actually, answer that, that would be a wonderful for us to see in terms of that. So I'm going to launch the poll. So just in terms of what you will see for people who are attending, it's a simple question. The question is, are you a beginner in this process? Are you a very experienced process? Or you're just learning something new? Tell us, what our audience is so we can tailor it, some of these answers for you a little bit better. Okay. We got some great answers coming in. So I can get the rest of the team members or people in the audience to maybe just answer out those questions. Yeah. And it looks like we have some great mixtures of good people here, Gloria. We have people who are frequent users, roughly 50% are frequent users of the I-9. And I will actually show that to you in just a second. We're going to close the poll for those of you who have not yet voted. If you'd like to take them in a couple of seconds more, we're going to keep it open. Okay, wonderful. I still see people voting, so I'm just going to give that just a few minutes more. Okay, all right, so we're going to close out the poll. And for people who are really interested in seeing what that is, I'm just going to share that. So you should be able to see what those are. But the greater majority of frequent users, Gloria, roughly 40%, 39% are experienced practitioners. And then we do have people who are beginners and people who are just learning about this I-9 process for the first time. Okay. We have a second.
I see.
Okay. And we do have a secondary poll that maybe we like to bring up. in a later part of this, but let's go back to what showing maybe our slides are, right? So I'm going to hide that section out. And then we are actually going to take a look at, some of the questions that actually came up in this section right now. So I think our first set of questions really are going to come through. Let me know when you can actually see my slides here. Let me know whether people can see the questions. Dan, can you confirm you can see the questions?
No, I don't see them yet, Thomas.
Okay. For some reason. Okay.
Present. Oh, here they are. Okay, for your first question, Gloria, how can I make corrections to a I-9 List B or List A document if I notice the document number had a typo and needs to be corrected?
Very easy. Again, if a correction needs to be made in Section 1, you would call the employee into your office and have them make the change in Section 1. If you notice a incorrect number or information in Section 2, then you, the employer, could go ahead and make that correction.
Okay. So if Section 2 was completed then by a remote agent and the HR user notices this error during the document review prior to submission, can the HR user correct this? Another question.
Yeah, let's see. If Section 2 is completed by a remote agent and the HR user noticed this error during, let me see if I understand the question. If an employer assigns an agent in the field to fill in Section 2, and if the employer, let's say at headquarters, realizes that there's some incorrect information in Section 2, any type of error, that employer is free to go ahead and make any type of corrections to Section 2.
Okay.
Next question. Okay.
So again, here's a compliance question. For completing Section 3 of the I-9 for a U.S. permanent resident or U.S. citizen, do I need to see an unexpired document again, or can I fill in the new hire date? The person, okay. Go back, thanks. The person was e-verified before and cleared. So how would
okay. Yeah, okay. This is a good question. You don't have to re-verify or update Section 3. Let's see, can we go back to that slide? The previous slide. Oh, okay. Yeah, at any time that a employee gets a employment authorized answer through E-Verify, you do not have to put that information back through E-Verify at all. That's not permitted, meaning you don't need to put that Form I-9 information back through E-Verify. Just make that change in Section 3 if you need to update their name or if their document or what have you. That's where you would make that change. That's where you would update. That information would not have to go back through E-Verify. So again, you would not have to create a case in E-Verify a second time for a rehire, and particularly when they get an employment authorized answer and if they are a U.S. citizen.
Great. Next slide. So what is an auto extension? What do I need to do complete an auto extension of a work visa or an expiring EAD card?
Right. Well, first of all, the employee would have to present that expired EAD card with a Form I-797C. They must bring that Form I-797C in with that expired EAD card, and you would just put that information into Section 2, and you can put information, a notation in the additional field box in Section 2 as well, additional information box in Section 2.
Great.
And well, let me add one more thing. The auto extension means that people in certain visa categories, their employment authorization to work here in the United States has been automatically extended by the Department of Homeland Security.
Thank you.
The next question.
Do we need I-9 forms for both employees and contractors? We work with interpreter and translator contractors here and overseas. How would we address that?
Okay. Yeah. Well, you don't need a Form I-9 on file for anyone that is not your employee, and a contractor would not be your employee. Also, you don't need a Form I-9 on file for any employee who is working overseas or what have you. So the Form I-9s do apply only to employees who are working here on U.S. soil, and you do not have to have a Form I-9 on file for contractors because they are not your employees.
So, and I think I just wanted to clarify a question that was related to this, and that is a question that if they're working, as an employee, subcontractor to the U.S. government at, let's say, an Air Force in Afghanistan or the U.S. Embassy, which is technically U.S. soil, would that still need an I-9 for that U.S. employee at those locations?
Someone that's working overseas at an embassy?
Yes.
Okay.
No.
Okay.
Mm-hmm.
Okay. If I employ a U.S. citizen abroad on a U.S. government project overseas, would they be required to complete? So this sounds like a similar question, an I-9 form.
Yeah, I think this is similar. No, you don't have to have a Form I-9 on file for anyone who is not working in the United States.
Right. Correct. Next. When you have a rehire, is it a better practice to have the individual complete a new I-9 form or just use their original I-9 form?
Well, we always recommend employers to just complete a new Form I-9. It's always easier. You're free, of course, to go ahead and update their information in Section 3 if you like. However, we always recommend just to do a new Form I-9.
Next. What appropriate steps can we take when a new hire started working before an I-9 was completed on time and correctly?
Okay, so in other words, the individual started work before they completed a Form I-9 is what I'm assuming here. So, of course, you're going to want them to complete that Form I-9 as soon as you discover that error, and be sure to put the accurate dates as well. So whatever that person's hire date was, whenever they began work, that's when they began to collect pay for work. You have to put that date into the date of hire date, and the date that you examine Section 2 documents, you'd have to put that date in as well. So just be sure those dates are accurate, and you would want that employee to complete that Form I-9 as soon as possible.
Mm-hmm. Okay, we have another question. We discovered a late completed I-9 on an audit, and the I-9 was completed later, and then the 3-day window. And this is what we're talking about. Are we subject to a fine during the USCIS audit?
Well, all employers do have that good faith defense. It was only, an error where, somehow the Form I-9 didn't get completed by the employee, or, the HR person didn't give them, the Form I-9 in time, or what have you. So it's not necessarily that anyone was doing anything nefarious. So what you want to do is just make a notation as to the dates again, that the Form I-9 was not completed, by that time that the employee began to collect pay for work. And in terms to being subject to a fine, that depends on if, you were ever audited by the government and they were, aware of this discrepancy. So that's pretty much all I could say to that, because if ICE, chose, you wouldn't be subject to any type of USCIS audit, but if ICE chose to fine an employer because of that error, I can't really speak to that, because when they issue fines, it's based on a technical error, I think. And if they define error as being substantive or technical, that's when they issue a fine. But again, I really can't speak to what ICE would do.
Gotcha. Okay, we have another one. Due to COVID-19, we started an employee and termed the employee before we could verify his documents. What do we do if we cannot complete his I-9 and verify his documents before termination?
Let's see, due to COVID-19, you're still supposed to verify those documents. Everyone, please keep that in mind. Although we are working remotely, that does not excuse the fact or the burden on employers to verify those documents. You must have a current Form I-9 on file for your current employees. The person, if they're no longer in your company, and if they did not complete a Form I-9, if you wanted to maybe track them down to do so, that's your prerogative, but just keep in mind you must have a Form I-9 on file for your current employees, and that individual you're speaking of now is not a current employee.
Excellent.
So we'll take a look at any questions that actually came in on the chat session. So let's take a quick look there and see whether any questions came up in that little section. Okay. I think we have. Okay, and I think there are similar questions that has come in. What if a Form I-9 was completed? What if the Form I-9 was completed within 3 days, but the employer didn't bring their IDs on time? I'm not sure how to understand that question. Seems like they completed without seeing the document. Mm-hmm.
Okay, well, an employer can give an employee up until 3 business days to bring in those documents to establish their identity, as well as their authorization to work in the United States. If they don't bring in those documents within those 3 days, that employment should be terminated. And I don't know if that person we're speaking of, if they're any verified participant or not, but that would be the rule. So if they're saying that the employee did not bring in the documents within 3 days, but they went ahead and retained that person as an employee, I think that's what they're saying. So, I mean, if you documented it, you'd want to put a short memo on, the Form I-9 to state that Joe Blow brought the documents in 5 days later. You can do that because you didn't terminate that employment.
Okay. And I think we have a related question here. If I had an old I-9 that someone just wrote on Section 2, please see attached, and we have a copy of the documents with it, would I need to fill out a new Section 2 and put all the original information on it except for the date I redid it in Section 2, then attach it to the old forms? I think the question is, They didn't complete section 2 completely, but they just said see attached documents, and they have to redo it. Is that a good process? What would you recommend there, Gloria?
I would recommend doing a brand new Form I-9 and completing it properly, the way it should be completed. You don't just write, see the attached documents. No. You are to record the information in each box in Section 2 of the Form I-9.
We don't have E-Verify. During COVID-19, we are onboarding new hires remotely. Can we accept a fillable PDF with typed-in signature for new hires who don't have a scanner? And I think this goes back to the signature. It is a typed-in signature on an electronic form. It's not a physical signature. Is that an acceptable signature?
During COVID-19, yes, it is.
Okay.
During the COVID-19 era we're in. Because when the office, that employer's operations resumed to their normal status, all documents would have to be physically examined, and at that time, that's when you could get that signature on the document.
So there's another question here. If we have students that work for us in the summer, do they need to complete an I-9 form? Some of them are in high school and work temporary hours. And I think the question is there a work for pay here? But do you want to actually maybe elaborate on that on that answer?
Sure. Just it sounds like, for example, the lifeguards who, are hired at parks in the summertime or what have you, as long as you still have that Form I-9 on file from that previous summer, that Form I-9 is fine, and you would just update Section 3 in the rehire area just to, ensure that they do have documentation or the picture ID or what have you. So, for rehires and for seasonal employees, just update that Section 3 area and you'd be fine.
So I think there was a question on the fillable PDFs again, and whether a type signature is acceptable for in the interim COVID-19 situation, and I think you answered it, so we're not going to take that question again. But I have a good question.
Oh, go ahead. I'm sorry.
No, finish, Gloria. I didn't mean to interrupt.
Yeah, and just to clarify, it should be a signature on that PDF and not just a type, let me type in my name. So I want to kind of clarify that if it wasn't clear before.
Okay.
So there's a question here from David, which I think is a good question. But David is Davida Carlson. I'm sorry about it, Davida. But if we have moved to an electronic I-9s and still have paper ones, can we scan and upload the paper I-9 to an electronic system and shred the original I-9? Or do we have to retain a copy of the paper I-9s?
Yeah, you can do it either way. If you want to retain the paper, you're perfectly free to do so. Or if you want to dispose of the paper Form I-9, that's your prerogative as well. You can keep both, or as I say, if you want to dispose of the paper, that's fine.
So with the COVID-19 layoff, do we need to use Section 3? Does the employee have to be off for a certain number of days? So I think the question really is they completed Section 1 and 2, and maybe they are rehiring them back because of COVID-19 when they're coming back. And the question is, do they need to complete Section 3 for these employees that may actually come back and rejoin, even if it's only for a couple of months, that they were laid off?
Yes, that's correct. You still need to complete Section 3.
Okay, so I think this is an easy question for you. If a new hire and payroll are both working remotely, do we still need to view documents within the 3-day window?
Yes, and you can do that by way of fax, video link, or email.
Okay. And I'm sorry we couldn't get to all of your questions. There's a lot of questions we received. What we will try to do is actually try to consolidate some of these questions back to you. So do look for a follow-up email that may have some of these questions with some written responses. Our team has made a recording of this so we can answer back some of these questions to you. Simple ones to answer. If you need to send it back to DHS or USCIS for clarifications, we will do that. And we will try to reach out to you with some of these questions that we couldn't get to. Once again, I do want to thank all of you that actually attended and this webinar. Thank you so much for your time. We appreciate the opportunity. And Gloria and Dan, thank you again, for taking the time to present this webinar with MTrust.
Welcome.
Oh, you're quite welcome. It was my pleasure. Thank you for having me.
Yeah, thank you, Gloria. Thank you, Thomas.
Okay. Thank you all, and be safe and keep well. Bye for now.
Okay. Okay. Bye-bye.